Spring crickets. A lot of activity. Heard a ton of activity here this last week, didn't we? I hope you did. Kind of give me an opportunity for object lessons and things and testing what I might know and what I might not know. If you haven't heard what was going on, and I wasn't really going to talk about this, but things are coming on that I need to get something on the record about it, I think. Because wrong actions can have a lot of dire consequences. What I'm talking about here is that there was a flare-up with the miners out west in Oregon. And an agency called the Bureau of Land Management getting all involved about where in things that they claim to have authority over to interfere with a miner that seemed to get out of hand what apparently was pretty quickly, within moments, within days, within hours, that the Oath Keepers were called in to protect the miners' constitutional due process and property rights. That I remember, I tell you, I play the crickets. Crickets is the metaphor, if I can say it that way, with the us not acting properly, us not taking responsibility and taking action that's appropriate and resolves an issue. Whether that issue should be there or not, it needs to be resolved. That we can still be acting and doing something, but if it's not proper, it acts as silence before the oppressor or the authority or one purporting authority. That I've been really critical about. It's not just about how much action and motion. Again, you can have a car revving up and you can put that thing in gear with the engine way revved up, and you can have those tires spinning like crazy, making all kinds of smoke, but you're not going nowhere. You got to get that rubber to the ground and lock up and go to get something going. With all the energy you're putting in, are you going anywhere? And that's what I've been real critical of. And it's a two-part problem with the crickets. Not only do we have to act, but we have to act appropriately. That this issue came on, and I got to thank a lot of the people that contacted me. Appreciate you giving me the opportunity to inform you about this, because the Oath Keepers were called out and they rallied up. They rallied up to protect the miners' constitutional rights. And I don't want to be judgmental at all of all of that. What I recognize, because I do this a lot, folks, I help miners a lot. And it's always almost on the same thing. It's about the only thing the BLM really can come after us at. I help miners, address the problem that this mine owner's having with his property. And so something sounded way bad that it went so fast to having to have the Oath Keepers come out to protect the miner. That I think my impression was, where the BLM had stated that they had made a decision and told the miner to take out his claim and then he'd get a hearing, was not only administratively wrong, but it was well beyond the demands that the BLM could make. That my intuition is still telling me that this is a condition for a setup for a takedown. And what the setup, what it's going to do eventually is going to get the precedent that non-applicable law, non-applicable to certain minerals granted in the law to entrymen, miners, grantees, was going to be subject to regulation by the BLM. They've been wanting this bad for a long time. That when this thing flared up, that the Oath Keepers are called in to protect the miner, that the BLM was going to come in to destroy the claims. I said, there's something not right here. That this sounds either like someone doesn't know what they're doing administratively, and or this is a setup for a takedown. They're going to get their precedent, and then we're going to have a lot more work. That I started paying attention to this very carefully. And I thank you for all the concern that I was involved, or that I might be involved, whether or not that was to be part of what was going down, or just that our claim may have been involved in. And I told y'all that I wasn't, and we aren't. And I talk about me and my partner, and or also extending it to Jefferson Mining District. We had not affiliated with what was going down. That I'm still looking at this because I'm here to help miners, and I've offered to help offered to help both of the claimants. One of which turned me down outright, which is fine. I don't have to be everywhere. But the fact that this went to the point that, way back when, and when I was on the first network I ever started broadcasting on, I started to do, I did a 3809 interpretation. I'm going to do a little bit of that today for y'all, just to show you how quick this is supposed to be resolved, what it should have been resolved. And to show you how far things can go bad quick, that when the trigger was pulled about pulling in the Oath Keepers, and then, unfortunately, seriously and unfortunately, it was likened to be as if it was a Bundy rancher condition, that this was setting up really quickly to be going a bad way for a lot of reasons. That I got very concerned because we tried to stop this kind of thing when we first got involved. When we were talking, I was telling you a little bit about the Southwest Oregon Mining Association. This is prior to Jefferson Mining District. That we went to, and I don't know if it's ironically or consequentially or what, coincidentally, the same deputy is involved in this issue that was involved with me and my partner in the Rogue River, that allowed us to go to Sheriff Gilbertson when we figured out then that the sheriff's deputies don't know mining law, and they don't know the due process required to a property owner, essentially, or producer. That Sheriff Gilbertson stepped up and took our findings, our research, and he decided to redo his own, and he did I can't commend him high enough about the work that he did to understand what he started to understand, and that he did step up to say, yeah, he understood that this is a property right, and you just don't come in and tear out a miner just because you say so, and just on your own authority, even as a federal agency. There's real requirements here, because you're talking about land disposal. That when I saw this come down, I said, this is a setup for a takedown. Something's way wrong about this. But we weren't on the inside of the information, so I've had to wait and watch and pay attention carefully. And I didn't make. I had my intuitive sense, and then we got into the BLM. Finally made a comment, and just on the BLM's one paragraph comment, I was able to at least conjecture with, if I can say that, an educated guess, what we were dealing with was in fact this a 3809 rule imposition. And I suspected, because they were talking about the miners' cabins, that it also included CFR 43 CFR 3715 rule imposition. That's for occupancy. Now be careful here, because this is where it gets really technical, and why the words make a big difference. That miners have a right of occupancy. Occupation. That's to possess that land and occupy it as a settler. But the rules talk about occupancy more like a house. And that's exactly what they were talking about, the BLM was talking about. That I conjectured this was a 3809 rule violation, a 3715 rule violation, that for every miner that comes through to come to for my help when they get their notice of noncompliance letter, we answer this pretty quickly. It usually only goes to a second letter. And the second letter only happens because the BLM thinks that they are going to press what we identify for them in the second letter as a felony. At least one. There's lots. Actually, it's 3 or 4 felonies. And so I realize, again, if we've got this thing going into the Oath Keepers and all this, and then the potential danger, like we saw how close Bundy came, that this got out of hand too quick, that something was terribly wrong on a lot of areas, and I thought that I could explain for most people listening. I guess for today I wanted to get on the record how simply we can find what the answer really should have been and ought to have been. That one of the mine owners came to the Jefferson Mining District meeting here Friday to explain to us. He wanted us to know what was going on. Again, we were never a part of understanding what was happening. It just happened. And I appreciate that he came in to discuss it with us, so we know better. And he confirmed to me, in fact, it is a 3809 violation, a 3715 violation. In fact, and this was my problem, they did not make the record of this 3809 condition. And it was just confirmed to me, and why I wasn't going to talk about this, but because it was confirmed to me today, in fact, again, that what I've suggested needed to be addressed was something to address. I'm wanting to get on the record that this was a critical administrative failure. That the arguments that are being placed right now in the public's awareness are essentially irrelevant. And what's happened right here is that the mining claimants, without knowing it, if they did know it, I have a question, but if they didn't really understand this, they're not directing themselves to address the administrative demands, and the BLM has suckered them into taking on an argument about without arguing that whether or not the 3809s are applying. They're arguing that they do by arguing the extent. And for those of you that have heard me before, I've said that's the same thing of going to the IRS when the IRS comes against you and you say, well, I don't agree that the amount that you say I owe you. What have you just done? You've agreed to the underlying authority to go ahead and levy whatever the fee is. What you have to do is argue that they didn't have the right to levy the fees. You don't care what the price is. You don't care what the value is. That this is what's going on in this case. That I want to read you just a couple things right out of the rules. And I seriously want to tell you that all the arguments that you're hearing, everybody on every side, is irrelevant at this point in my mind. Yet the record has yet to be made about this point that I think is critical, because if you don't do this, you haven't shown that the rule doesn't apply. The authority the BLM's claiming to come in to try, well, they're actually, I understand now that one of the miners believes he's under a valid stop work order. And to show you the extent and how ludicrous this is, the BLM is claiming they have rights under the surface to be able to tell the miner to shut his mine shafts down. He's got hard rock. It's a load claim. And so this is a transgression by the BLM that no one is checking on the administrative side, the administrative record of which becomes the only thing on appeal. And if they don't get this recognized, all their discussion around this will fail. And we've seen this quite a number of times until we started making this record. The other thing that came on is some questions came up since we were discussing it Friday about this 3809, and I made some just preliminary suggestions of what to check out. And I'll go over to it, but you can find it on the internet. You look at the scope and the purpose. And so some questions have come to me from miners about interpreting this. And I want to call your attention to when we go read it, you're listening for something called the public land, and you're listening for a different thing called the public domain. And now we're back to the terms being so very important to understand and to make them important. And that there's a question also as to, when you read through the rule, you realize as a miner that it doesn't, it looks like it acts before your notice of location, actually. Or what we call location notice, which is your title as a miner underneath the law of 1872. So, and I appreciate that observation, because that's a little bit deeper understanding that in fact these rules don't pertain, and I want to show how that is. And a location notice is not even involved in the mix. It's not even that it's before a location notice. It's that location notices don't exist within the rule set, and we'll see why. Because a location notice references a disposal. It's the evidence of a disposal of land, and it's not a continuing management authority on a public land. And so, if you listen very carefully to what I'm saying, I'm going to go through now the rules, just a couple rules. I'm not going to read on and on. I'm just going to show you. We read the beginnings of this, and we should be able to, once we find out that there's no authority in the BLM to do this, we will recognize very quickly that what they're doing to create the interference with the miner was out of authority. It has no jurisdiction and no authority and no power. That is not in the record as of yet. That when you find out that they're using this color of authority to interfere with the miner, and now he is agreeing to a stop work, and probably prudently, being that you see what happens if you don't believe, if you don't agree, then what happened with Bundy, it could become Bundy-like. That they even characterize it like that was a real serious problem. We really can't go there because it causes people to do things that we don't want them to do, and that's all of us. We start to think in certain ways, and we don't need to go there. The law, I tell you folks, the mining law was to create peace, and when we're into this level of non-peace, you know the law is not being followed. I'll just tell it to you that way. But let's go to the rule. Now, the rule's not the law; it's as law. It's the law. It's the rule. It's the law only if it's compliant with the law. Yeah, but let me show you where this does affect, who this does affect in a couple of different places. And this is in a way that Reagan had laid it out. He says, we're not going to tell people the law so well. We'll give them a question that they can read, and then we'll give them the answer to the question that we propose, and we'll answer that question so that they get an understanding on how this works and what this is about. And that can be kind of helpful. It's not the truth, but it's kind of be helpful. But listen very carefully here on what the purpose of this 3809 non-compliance order is about, what it's trying to stop, what the compliance is supposed to be, is to prevent unnecessary and undue degradation of public lands by operations authorized by the mining laws. This is the purpose. It's to prevent unnecessary and undue degradation of public lands by operation authorized by the mining laws. Now that sounds like it's the mining laws. It sounds like it's all the mining law that there is to do, but I'll tell you the mining law is in two parts. The conveyed part, the granted part, and the one that wasn't granted, and that was the common minerals. That I won't go too deep into, just to let you know there's a split. One of them is continually administrated by the public, by the BLM, and the other isn't. So what we're talking about is public lands management, and this rule is over public lands. Let me go over quickly to the grant, the 1866 grant, where Congress disposed of part of the mineral estate of certain minerals. And then that was in load. This is the law we're talking about here. And right out of the law of 1866, we'll hear where mineral lands are located themselves, where are they actually situated. And it's right in the first part of the paragraph here. It's that the mineral lands of the public domain, both surveyed and unsurveyed, are hereby declared to be free and open to exploration and occupation. So let's go back to the top and say that the mineral lands of public domain. Well, the mineral lands are of the public domain. Does it say public land? No. Public land is defined as land open to disposal. Public domain is that which is disposed. These are two different areas. So, before, I'm going to get too complicated here. So we go back to the thing. Public land is not where minerals are when they're disposed. Remember that 1866 is a grant of disposal of the mineral estate, certain numbers of it. It gets changed in 1872, not to just the enumerated minerals of 1866, but in 1872, Congress expands that grant to all valuable mineral deposits. In other words, things that were not listed and things that were at the time known in 1866 to be valuable were now included. In this case, you can have a silica deposit, which was not then known, but of a highest quality, because silica is normally just sand. Sand is a common mineral. You can't claim that. That was illegal to possess off of public land up until 1947. But silica sitting in a deposit that's of high quality and purity, such that it's medical quality or has some industrial quality that's refined use, very valuable in addition, that is claimable as a valuable mineral deposit under the 1872 Act. That these minerals are in the public domain, the rule over which only applies to public lands, those lands that are yet to be but can be disposed. So, first of all, this rule doesn't even apply to the Sugar Pine Mine. It doesn't apply to any placer entry. It doesn't apply to any valuable mineral deposit entry, because those deposits, once located, are on the public domain. They're not of the public land anymore. So I hope I'm going kind of slow here, but I hope you're picking up the distinctions, even for those of you that haven't heard this before or are not even really interested. I guess I want to lay this out for even you, because you'll realize if you go to the statutes and you read this carefully, you'll find where the government can't go everywhere. The agencies can't go everywhere. There's a limit. And this land disposal law is very interesting in that it's very clear of how it works and where the encroachment, that there's a failure of an ability to encroach and where that exists. It's probably unparalleled in its ability and clarity to be able to do that. Why I focus on it as well. Notwithstanding, I have to know this law. I'm a grantee of it. I have to know it. I could call myself a lawyer that way, not an attorney, but having to know the law. I live and die by this, if you will, if you please, on this point. That if I'm not in this law and compliant with it, I'm a trespasser. And that's pretty strict liability here. This is no corporate limited liability on this. You either are or you're not. And this is about title. So, the public lands are those to be disposed, but located and claimed minerals are on public domain, which is disposed. That the second part, point 2 of this, is what's the scope of the subpart. I'll read just the first part. This subpart now applies. We had the purpose. It's over preventing unnecessary and undue degradation of public lands by operations. Now, miners also don't do operations, they do work. Operations happen to be contract miners over the subject matter minerals that this is regulating. It's not the uncommons, not those valuable mineral deposits, and because we know that it's anticipated because we're dealing with public lands and not public domain here. That the scope of what this public lands is incorporates itself over. This subpart applies to all operations. Not the mineral, not the land, but the operations authorized by the mining laws on public lands where the mineral interest is reserved to the United States. Where the mineral interest is reserved to the United States. The Sugar Pine Mine being a lode claim, the rights of which relating back to 1866, the grant from Congress, is not minerals reserved to the United States. And this rule that they received a non-compliance order on is for violating this rule that is clearly in 2 parts not applicable. In the first section, in the scope, neither the purpose. Now, there's more to this, and we can read it, but it opens up more and more and more problems for the BLM. And again, I want to remind you, this has yet to be brought into the record, this fact right here. Which is why I knew the thing had gotten out of hand. And I'm very thankful and glad that the Oath Keepers were as cool as they were to keep, and the mine owner was as cool as they were to keep a lid on this. The mine owner himself stated that this did get out of hand with respect to going to an anticipation that there was a Bundy-like invasion by the BLM. And so cooler heads are prevailing in that regard. And I can't tell you how much I appreciate that. Because this is what I've been about for all the time you've heard me talking about the SWOMA Sheriff Gilbertson connection and getting the sheriff to come up to speed on this public land disposal law, which makes it a disposal into the public domain, which makes property rights that's against that can be held against even the government. That's in a serious matter. That if it's breached, it's a serious matter. That because it's breached at the Sugar Pine, and that record has not yet been made, as I tell you, when they come under a color of authority to cause a stop work order and cause that miner to stop, that's irreparable harm. Notwithstanding, they can't regulate the undersurface anyway. They can't regulate under the ground anyway. That's an irreparable harm right there. That he had to stop and feels he has to stop, and he's getting coerced and extorted into agreeing to an appeal that has a bad record set at this point. Is how the BLM starts to get their way. That I wanted you to know about that. So if this precedent does happen, and now we have a future mess to deal with, you'll know I'm on record today to tell you that the administrative procedures are all important right now to make a record. Why I tell you, for those of you that are in code violation problems, you make your record. This is where the failure in this case is right now. I'm absolutely certain of it. Now, I don't know that it would stop anything, because when you're up against a criminal, what is when does it stop, folks? And this is what we're dealing with in this BLM group. This is these are just, I just tell you, they're just criminals. And I know this because they're making war. They're worse. They're committing treason. They're making war on these laws. And we're attempting over time here to call all that out, that this is going to be one of those interesting cases that could go to a bad precedent. That I wanted to make the record today to show you how it'll be the bad precedent, but we've already identified it before it happened, haven't we now? Let me answer something else about this that most people wouldn't understand, but you also hear in the news that the BLM is ordering a plan of operations. We call them POOs, because that's about what you don't want to step in. But there's also something called a notice of intent that's involved, about notice of intent for exploration. Remember now, I said in 1866, the miners, the grantees, have the right of free and open access. Didn't I read that? Free and open. This rule says you don't. So this rule can't be talking to that grant. And everybody's rights as a grantee relates back to the date of the Granting Act by the relation back doctrine. This is not new news either, folks. I've been talking about this for years and years and years. Let me go touch one thing for those of you that are listening or will listen, that understand about notices of intent and plans of operation that they claim that you have to file. I've said this before, and I'll say it one more time, but in a summary way. Notices of intent have one definition in federal statute. They are not the notices of intent to hold that we file as minors. They are a notice of intent under environmental law, and that's defined. When that's defined in statute, that's the definition. You have to go to that law. A notice of intent means a notice of intent to file an environmental assessment. That's under NEPA. There's nothing in the mining law grants of disposal that require a NEPA position for the first point, and the second point is that it can't, because NEPA requires the existence of a major federal project plan or demonstration. Mining operations that are disposed land are not major federal actions. And it has a rule for this. This subpart does not apply to private land except as provided in paragraphs A and C. Well, A and C happens to be the minerals reserve of the United States, and C is the California Desert Conservation Area. Most miners have no claims on those two, don't have minerals reserve of the United States, and they aren't in the California Desert Conservation Area. But it says right there that private land does not apply to that subpart. What do you think an exclusive possession and enjoyment is, folks? That's the grant of 1872 is completed in amending the 1866 and 1870. The grantees shall have exclusive possession and use. Exclusive is exclusive. That's private, folks. So these subparts are stated not to be there, but that the BLM can use, can approach it for collection of information purposes, things about private land that are near to or may be affected by operations authorized under this subpart. Well, guess what? Our authorization's not under this subpart, first of all. They're not operations. Secondly, they are exclusively possession. They are a private land. And so this act, whatever these minerals are, the operations and contracts of production, of extraction of which are not to affect other private property like the grantee's property. So what kind of a mineral are we talking about? It's not the uncommon mineral. It must be the common mineral. Those minerals reserved to the United States under a prior entry. Now this rule is a pretty bad rule generally. I'll just tell you that. But we can pick apart this thing that there was no reason in my mind that this needed to go where it did. And I want us to be knowing, and I want you all to tell, because this story went across the country, and we got links from to Jefferson Mining District from across the world coming in to see what was going on in Oregon about this when the Oath Keepers started to go in, and everybody was heading in to protect that miner, and I thank you very much for doing that, and I continue doing that. This is not over that way. But to raise the temperature of this up to the point of a Bundy-like condition was very, very dangerous. Now, I'm sure that started to get squelched pretty quickly, but there was no reason for this to come this way. When you read this and you find out that the BLM had no jurisdiction whatsoever over this land that was segregated by its location because of the valuable mineral in it, because of the rights that relate back to those granting acts. They predate the BLM, they predate the regulations, they predate all this, and the miner takes subject to his own entry and subject to the time for purposes of muniment. In other words, you have to follow state law today to perfect that claim, but his rights of working it and what he gets entitled to relate back to the granting act. And there's nothing the agency can do to change it. In fact, there's nothing that the courts have jurisdiction over but to affirm that fact. In other words, to come contrary to it, they are committing a crime. That this record is yet to be established, that these rules were improperly applied by the BLM. And as I've told you before, they've come under a color of authority to interfere with your rights, property, remedies, or interfere with you, having you to have to do something. That is felony. And for those of you listening that may involve yourself, if you find a state felony, which I've told you where that is, I guess I'll give you the number, ORS 164-075H. That's where you're going. That's the state felony. You kick it on over now to the federal felonies. You got scheme and artifice under mail fraud, and you also have honest services as 2 felonies, and there's a couple more. I want people to understand there's a way to address the government, even with the government's rules. The government is criminal. I get that. But we have to respond accordingly. And you have to understand there's limitations, but the words are black and white. I say, get the black and white in your eyes. It's right here for us to see. Let's go to put lead to paper instead of immediately going to the barrel of a gun. Now, initial presence may have been needed. I'm not going to judge any of that. I'm telling you, though, we need to do this a lot more smart, not smart, intelligent. No, smart's not so cool anymore. Smart's not technocracy. That we can see, the rules are right there for us to see very quickly. That the government agency that applies a non-applicable rule is committing a felony. It's committing a trust breach. I can go on and on. I don't want to do that. I just want to be on the record. That yet to be put in the record that's already apparently going to go to an appeal is omitting this fact that we're looking at a setup for a takedown. And I will not, if this goes on and they don't get that in, and I already know the corruption in the IBLA. The IBLA is the Secretary of Interior's appeals court, which is the apparent voice of the Secretary of Interior, and we already know they're corrupt. So thinking you're going to a judiciary or their quasi-judiciary is going to be a mistake if you think you're going to get justice. This has to be clearly on the record, and you have to avoid those at all costs because the record says they can't have jurisdiction. This is a whole other different level of gameplay, if I can put this in this context. This is a war, folks. This is how you have to go about this. We shouldn't have to. You should think that the government is recognizing their own laws. I think I've clearly proven they're not, and yet that thing continues. And what's that thing I'm talking about? Well, that thing is the underlying continuing agreement that crime is allowed to be continued under the color of authority while the sheriff watches. And as I said, the sheriff that involved himself with my partner and I in the Rogue River while we were mining there, and gave us the opportunity to go talk to the Sheriff Gilbertson to get this start to be worked out, is the same sheriff deputy that approached these miners. And let me see, I've got the quote here that's very important to understand. He said, after the miner said, one of the miner claimants said that they're being, they're constitutional oriented. They want to make sure that there's rights in the Constitution that are recognized. And this deputy says, I have an issue with the Constitution. Now that's interesting, don't you think? So we have an issue with this deputy. This becomes very serious for Jefferson Mining District and the new sheriff in town. Because this deputy also, I understand, and I got the clarification from the claim owner about what was said that day. And he said that the sheriff deputy said when he came to give the paperwork for the stop work order, he said, you guys have a stop order. I'm here to serve these papers in person. Well, a stop order issued by the BLM has no force and authority. That sheriff was required to identify the lack of authority in the paper and not allow his deputy to go serve it. Why do I know that? Because this rule says it has no validity. And that sheriff has to know this stuff. There's another breach, folks. So this is a very serious thing. For me, it's a lot of work for us as we look at this as a district. It shows we still have a lot of work to do, but it does give us now a focus to what we work on, to try and keep these kinds of things below the boiling point, and below even that there should not even be a simmer going on, folks. The law settles this thing. There should be a settling. There should be peace and tranquility. I keep telling you this. In land disposal law, the thing the attorneys don't know. How do I know that? For sure, an attorney told me. Who was that? Ken Ivory, the representative out of Utah. He goes, we attorneys don't know about this land disposal law. Well, folks, I'm a minor. I do. And you should too. If you don't know about property, you probably are property. How long have I been saying that, folks? And so here we have a non-property administrative imposition on a property possession, and we are up to the point where we have guns in this country already coming out to protect this guy. We failed already. And so, not to be too much more critical, I'm here. I've offered to help. So some of what I've said has just been picked up on some private communications. I don't know whether or not it's going to be executed correctly either, but this is also the point. I tell you, the knowledge has to be properly applied. And in this case, this thing blew up way lots. And I could tell you, by dealing with the BLM prior on these very same issues, that it never needed to go here. That the BLM is using this, as I said, we were invited because he asked to hear about the mining law to Lars Larson, the interim chairman for the district. Ron Gibson and I made that meeting. I can tell you that lasted about 12 minutes until we started telling him what the law was, and we got kind of clicked off, kind of unceremoniously, but that's fine. We got 12 minutes to explain the truth in the law to a bunch of people. Found out who he is. I'm not too impressed. But that this is a condition where the BLM imposes wrongly, imposes without authority, and then extorts from the property owner, whomever that is. It could be anybody. It could be a grazing rights. It could be a timber entry. It could be anybody. Imposes on them to engage that agency and extorts an engagement or an agreement out of them to gain the authority they need. The IBLA or the courts will give them that authority despite the extortion. And what if I tell you about your civil rights? You're subject, when you put yourself in that status and don't stay in the status you need to be, and you give it over to them, you get to suffer exactions of every kind and no other. And for those of you taking notes and read it, go back to read it at 42 U.S.C. Section 1981. You get the rights to pains, penalties, punishments, folks. You don't stand out and you say, "Wait a minute, you're not gonna give me the lashings here. I'm here to give you the lashings." You're behind the woodshed. And this is a more simple answer. It's not so drastic. All you do is you point out, my claim's not on public land. I am not claiming mineral interests. See, interests aren't possession. That's just an interest. It's the contract you have for getting the common mineral off the state. That's not a possession of the land. That's why there's surface rights entries over those. That's a crime. We're not going to touch that. The point is, this is not, a claimant does not take minerals reserved to the United States. They're taking the minerals that were granted to the possessor that claimed them. These are private interests. This is private property. And this statute says that private property is not supposed to be interfered with, right? In fact, it's supposed to be protected if you look closely. And so there's a major failure in the record at this point that would have called out the crime. And then there's that side of it, that if the sheriff was really paying attention, and this is not a judgment, because we all are in this same ignorance problem. If the sheriff was paying attention, the deputy would have arrested the BLM agent coming to purport legal process to a miner to stop work on his claim. the sheriff would have went down to the ones who implemented this whole scheme and artifice and arrested them for felonies. He would have recognized there is no due process at this point, and that whatever the miner is now having to contend with, that he had to call in this was a inciting riot and insurrection on the part of the agency. And I hear crickets on all of this, folks, is what I keep telling you. There's lots of energy going on. There's people coming from all over the country. There's the miner standing up, he thinks, for his rights. He starts arguing about certain things that are really irrelevant. He's not supposed to be in the condition anyway. The BLM keeps pressing. They keep wanting to negotiate, and they got no authority. That's crickets, folks. That's acting wrongly in the face of the tyranny. It's not stopping, is it? And we know that because it's not stopping. If the sheriff was if the BLM had done their job, it wouldn't happen. This wouldn't have been started. The sheriff would have done his job, and the deputy was there to do his duty, not job. It would have ended right there. If the miner turns around and now makes the record and then goes after them all, I don't like to see it, but that's what has to happen. Why? Because duties failed. Dereliction occurred. You want to empower the law? This is how you start to do it. And then what's the expectation? It's not a silver bullet, is it? Why do I tell you that? Because we live in a criminal society. I've said we have been derelict on our duty to push this out there and understand we are the ones to arrest the crime when the officials fail. And this is a big deal. This is not a judgment because we're all learning how this works. Why last week I brought up what's so important to find out those veterans back there in Illinois, what they're doing to their local officials that are not compliant with law. They understand that the inherent right in the people to make the arrest is no different than the right that we've extended over to someone else with a uniform. We're not supposed to allow wrong around us. If we do, you see what happens. And now, when it gets official, you see the tyranny that happens. So we've been advocating return to the law, and because of the mining law told me, you have to stay term specific, and that differentiates you from others, and whether or not you can identify a servitude or not. That was all powerful, all key to what we have to do, and never, never, never stay silent on a threat or trespass or inquiry that appears to have some officialness to it. I guess I want to get on the record. I am not being judgmental here at all in my mind. For anybody who thinks contrary to me, and I'm kind of insulting an intelligence or this or that, or talking against anybody's action to this point, well, except for the agency, they're criminals outright. So, but short of that, see, they've caused this problem that we are short of understanding, and it continues because we don't have the fulfillment of the knowledge that we need in the action to stop it, which I see should have been an arrest the day the BLM walked into the office with the stop order to the sheriff. Why? Because I just explained it. The miner's claim is not on public land, neither does a valuable mineral deposit equal mineral interest reserved to the United States on an unappropriated space. I have to say that particularly because this rule is so screwed up. They tried to throw so much in. I know where it applies, but it doesn't even apply correctly there. But I'm not going to confuse the matter. I know that the mineral possession is in the public domain, not the public lands, and they're not minerals reserved in the United States enough to tell me that the scope and purpose of this act, this rule set, is not applicable. I don't need to go anywhere else. I don't have to go through any legal theories on other acts or other laws or other things. This does not comply with, if it's applied to a load claimant or a placer claimant, it's not lawfully applied, and or it says in its terms it's not applicable. End of story. Felony for anybody trying to impose it. Irreparable harm anybody acting underneath that imposed authority. That's takings, folks. That's a takings, but it's interesting, and we're going to get this back. Because this happened, there's a bigger power. I'm not going to talk about it here because people take my information and don't use it right. So, and I don't want to lose this one because this is too much. But there's something that really happens. The BLM's going to learn here at some point. I wish we had more people to do this. That you do this, you're not going to have any public land left eventually. It won't take the Oath Keepers, folks. Again, thank you for those stepping up. We all need to protect ourselves. But that this went this far, this fast, when I know it shouldn't have, means we have a lot more to learn, and we have now we have a direct point that we can point out how this develops. See, this is the same problem that Bundy had. It's not Bundy-like, this issue, but he did the same administrative failure. No one's looking at jurisdiction and authority here, folks. I do. That's the first thing you have to look at. I'm not making up anything. I go read the black and white like you have to. It says the scope of this, the purpose of this, is to affect operations authorized under the mining law on public land. And the scope is on the public lands where mineral interests are reserved to the United States, neither of which this load claimant is relevant. So, I think I've said enough there. As I keep thinking, I'm just going to repeat myself over and over. I've been repeating myself for years now, for years and years. I don't even know, 8 years now on this point alone. So, any questions about this, please, markonthebeast@yahoo.com. markonthebeast@yahoo.com. All the letter that goes out that says you didn't have rights, you've wrongly applied these rules and you are in felony conduct here, show, you don't even have to actually explain themselves. But there's more we have to end up saying. But that's as simple as this response ought to have been in the beginning. And we do this all the time, folks. I guess this is my frustration. I do this with miners all the time. They get this non-compliance letter, and we respond and say, well, in the initial letter, this is not applicable for these 3 reasons. It's not just these 2. There's a whole lot of other ones built into this. And we give them 3 or 4 or 5, whatever it seems the letter that the subject matter of their first letter is. And the BLM realizes they got somebody they better not tangle with. That's how fast it goes. When you get someone who's been told by Washington, no, you're going to go after these people. Well, we sometimes have to go to the second letter. If the miner doesn't respond timely, that makes a 3rd letter because now they think they got a weakness. But we still hold their feet to the fire on the non-applicability of this rule set. Not by what we think, not by our opinion. Well, I don't have to go to a court case either. By its own terms, it's not applicable. How clearly the agencies and employees have violated the law, making war on it, disturbing the peace. That's sheriff material right there, folks. I don't know why I'm having to even identify this for everybody as I start thinking about it. So I'm going to stop thinking about it. I start to get a lot more frustrated. People have arguments with me over this. It's fascinating. People who will later come up and say, "Oh, I should. Yeah, you were right. They did what you said they would do. Wish I would have listened better." And yet, we're still here, and I'm having to speak about it, and it's serious. That's why I'm speaking about it. This is no joke, folks. This is no joke. This is how it goes bad quick. And this is what's being set up in us across this nation on everything else that you see going down. Why your silence is their victory in the silent war against us. It's not so silent. They're telling us we're just not listening. Crickets. That's what we are. We're crickets, and we're hearing crickets. A lot of noise and commotion is not being other than crickets in this regard. We have to do proper action, proper engagement. So, I guess I'm gonna. It just repeats in my mind over and over. I've had people not listen to this, not go read it, look at it, and then disregard what it means, not know how to put it together, not know how decisive this thing is, and now I see not put in the record when it's critical to get that on. What record are you going to appeal to than the one that's been created by the agency? If you don't get this in there, that they got no jurisdiction. You understand the review agency doesn't have jurisdiction then either, does it? Oh well, only to affirm the law, which is the grant. But no one does this. The attorneys don't remember. The attorneys are attorneys. They're not even close to lawyers. They don't know about this land disposal law. They know how to draw things out forever. And this is my other question about this issue. I found out that they did have an attorney kind of early on, and he is doing some good things as far as asserting rights back, but that's almost a show to me. Why didn't that administrative record be clarified that there was no jurisdiction? The only thing I can tell you by experience is because there's no money in decisively. It's just like pharma, folks. It's just like the medical profession. There's no money in curing it. It has to linger. It has to create side effects. It has to have derivatives. And this is the illusion and the lie you're living, that the black and white clears up pretty quickly. Folks, this is so settled that back in 1914 or 1928, a judge of mining law looking into the system said, there is no questions about the mining law now. We've pretty much answered about all of them. And because of that, no attorney, there's no mining attorneys because they can't make a living. There's no claims. And because of that, there's really no judges that know mining law. And there's only a few of those mining law judges left. And when those go, this judge of mining law, writing the book Lindley, he expresses a concern for the miner in the future. Boy, little did he know about the eco-terrorism that would happen against us and this sustainable development that would happen, the rewilding of America, to know that property owners, producers, are in real trouble if they don't learn to do this right. Enough said. I'm going to move on. The war on terror will never end. Another confirmation, I told you this a long time ago, it's a war of terror. CIA director, war on terror will never end. Battlefield America, folks. How you liking that? How you liking that? We're going to stay silent on all this stuff? We can, and a lot of us will. And as I say that, I'm reminded, and thank you very much for the emails and the phone calls expressing that, to tell me you're out there doing something substantive, not just spinning your wheels, and there's a lot more of you. I know that. Thank you very much for that recollection, that recall, and putting yourself on the line. Continue. Just keep pressing. I'm talking about us more in a mass action. Don't give up. Don't stop. Find the black and white. Work with that. It seems to be pretty good. In other words, I want to rephrase this for that. The statutes are for the government actors. The black and white is their Bible. In fact, we've been told that by the BLM. Thing is, they don't really read it right. So we have to sit there to interpret it. I'm going to go back one really quick little thing. We've already determined this cabin thing with the miner through Jefferson Mining District intervention with a case in Oregon. Was the Dusty Ford case, and the BLM charged him with he was cleaning up his cabin to use it. And he was cleaning out truckloads and truckloads of garbage that other users had come in, not miners, but just people had thrown in there. And he got charged by the BLM with cleaning out his cabin because they want the land. They don't want him to have it. So this is where that was that court case I told you real quickly. They put 4 BLM agents on the stand, said the BLM had title. Then interim chairman Ron Gibson told the attorney, you can't let them get away without producing that title. She said, you're right. Got him back on the stand, and she said, can you produce that title? Not one of them can produce title to the BLM land or the title to the title to the land that the cabin was on for the miner. She subsequently asked the miner, the grantee, to get on the stand and asked him if he thought he owned that property. He said yes. She said, you have proof? He says yes. And what did he whip out, folks? But his location notice. That was then handed to the jury, who asked for the document of evidence of his possession, exclusive possession, and they affirmed that was valid, and he showed that he had possession and the BLM didn't. He won. That was a criminal charge. This is the same matter, except it's administrative. They're charging that this is illegal. They've already this same group has been beaten, this BLM group has been beaten by this argument. Why isn't that part of the record? Again, this is now willful, knowing, malicious, folks. We keep going on the civil side violations here. It's all here for us to do. We're only going by that black and white. It's right there. It means something. We have to make sure it means something. That's on us. That's on us. So, the war of terror is on us. Battlefield America. CIA director. He's telling you that. What did I say years ago? Same thing. Central Intelligence Agency boss John Brennan took part in a question and answer session at Harvard last week. The most important thing to take away from the event is that the nation's top intelligence officer does not believe the war on terror will ever end. And I'm telling you, that's global, folks. This is the plan, and we're doing it, not we, we only through representation. And so here we have an entire facade. The stage, the stage that I was talking to you last week is set. And we are continuing to be crickets on this. And then it comes out, I told you, what I had a problem with so-called terror events and the so-called terror Boston bombing, the setup. I told you that when the defense attorney came out to say that he'd done it, it was over. Why do we have a trial? It's a show trial, stage trial. Here comes the next week that the family members, not the mother locally, who was railing hard against the problems about all this, but didn't get rid of that attorney, didn't help to have the son get rid of the attorney. The family behind the scenes that we never heard of was completely against this attorney. And they wouldn't allow the change. In one of her first arguments before the jury, after entering a not guilty plea, Clark said that her client is indeed responsible for the senseless, horrific, misguided acts. But in committing these crimes, she argued that he was acting under the direction of his older brother, Tamerlan, who killed in a shootout with authorities soon after the bombing. This line of defense has outraged many of Tsarnaev's relatives who have tried to convince him to dismiss Clark and ask for a lawyer who will argue his innocence. Why do you even need a defense attorney if they just tell the jury he is guilty? His aunt asks. What's the point? So, the family was seeing this. They didn't get rid of that lawyer. They call it a lawyer. Is it a really lawyer? No. The attorney is an attorner. Attorns the property over to the government, to someone else. It doesn't have to be the government. And comes out and admit, do you think a defense attorney would at least remain silent on whether or not the client actually did it and let the state actually prove it? Do you think that'd be at least the most basic defense? That when she came out to say he done it, I said, what's this? This is a show trial. This is a setup. We can't believe anything. I wonder now about his mother. Who's in her back pocket? That she wouldn't move in to help. What kind of a defense was that? This woman, attorney, should have had a major complaint against her for admitting that her not putting up a defense or putting up defenses against the proofs that was the burden of the state to do. This is another one of those things, attorneys throwing you under the bus, not doing what they're supposed to do. You think they're doing it, but that they're supposed to do it, and they'll convince you they are, but they're not. What my main problem, where was the attorney not saying that this rule's not applicable and charging back that it was a crime for them to do that? If the attorney was looking out for their property interests. And we know that they're not because they're not trained in property. And if I didn't know it anywhere else, an attorney, a representative of Utah says that. These attorneys don't know land disposal law. And they don't. That includes waters. That includes highways, folks. That's why you can't go in there and get your rights. You have to be able to know them, and you have to show how the court's jurisdictions can't attach. You settle it before you get in. And if you get in, then you got to show how it's a fraud what they're doing under color of authority, right? As I keep telling you, the felony. It's a fraud to make the characterization, and it's a felony under color to do that when they took away some other thing you had that was in fact yours. And it's yours because it's a property, and the property has a law to back it up. And if you don't assert it, if you remain silent on your right to remain silent, you don't get your right to remain silent. How's that? What you get is you get the right to pay exactions of every kind. Got your civil rights. Title 42, Section 1981. That this was what that was. This was an extortion, and it's going to pass. And this kid went down where there should have just, folks. When you plead guilty in a court, don't they just go ahead and find you guilty? Show trial. Facade. Crime. United States government targeted second American citizen for assassination. We didn't hear about it, but there's a story now out, a lead article in the New York Times describing a debate within the United States government over whether to assassinate an American citizen. Brings into relief one basic fact: the United States is run by criminals. So now you've heard it by the Times, I suspect. How long have I been saying it, folks? How long have you known it, but what are we doing to stop it? This is the point. What are we doing substantively to stop it? And I won't go through the story. The government it will have justified killing you. NDAA, extrajudicial, no borders, world war by terror. You know that just because of that. As soon as they go extrajudicial, there is no branches of government. They've even overthrown international law. And I hear crickets. This is so clear to me, I don't even know what more to say. In fact, I don't know so much to say. I don't even want to discuss it to explain it all to you. But I do want to discuss something. I don't know what to say. I wish I could inspire in you more action. I mean, all of you that are doing something, that's fantastic. You do as you can and as much as you can. Those that are sitting around looking for something to do, please find something soon. This is really coming down hard. This is a notice that if you didn't believe me behind the woodshed telling you that they're going to kill you, the only debate was a political debate over whether they kill him. And the guy sneaks out because he gets out of not being killed because they figured he was better not dead than dead if they got him into a court and they could make some more legal precedent in the States. Figure that one out. You're being played left, right, and center, and I hear crickets. And while all of that terror is going on, and we heard about the Yemeni thing, there's a bunch of people stuck over there. Americans, United Kingdom citizens, we've got Russians, everybody. So Russia tries to go over there. We heard the story. Russia sends a plane. Well, they get diverted over into, I think, Egypt. Well, they make arrangements to get Russian aircraft in there. And guess what Russia does? For the heinous criminals Russia is, they start rescuing Americans and the British citizens. And we send them a thank you while we're putting troops in Ukraine, while we're allowing a ceasefire to dissolve and utilizing hook and by crook separatist type action to go on. I don't know if you know about this, but the ceasefire is essentially over in the Ukraine and people are dying again. You don't hear about that too much. But Russians stepped right up in this Yemeni condition and started to send planes in and started rescuing everybody that could get to the plane. And there's some people that can't get there. And American citizens were not thrown off the plane. They were not let on. They were put on. And so John Ketchup Kerry expressed gratitude for assistance in evacuation of American citizens. Folks, what happened to America? Not only did Russia step up, and thank you very much for doing so, for anybody, getting people out of the way. Thank you for doing that. But where were we, folks, as a nation? What kind of buffoons do we have in these places? These are, I'm going speechless again. And I hear crickets. I'm hearing crickets on this. We express gratitude? Are you kidding me? I think if we really expressed gratitude, we wouldn't be doing what we're doing over there in the Ukraine and elsewhere, and we probably would have had some planes picking up Russian citizens. We would have had a fight getting into the airport, you think? No. This is not the world that I was grown up to see that it was going to happen. I was not told about this new world order, that's for sure. And I keep telling you it's about a financial advantage underneath the skin of it all. It's about global financial control. And you see, I told you about the BRICS. I've told you that they're going to split the world so they have an adversarial condition. But the underpinnings of who controls what in this global order of governance of public-private partnerships moving into everything you do has been going on since at least Elder Bush. That we get the word Canadian Wheat Board no longer quite so Canadian. You've been sold. I'd be interested to hear who you've been sold to with respect to Yemeni. And this is a public-private condition that you Canuckistinians are being crickets on. But I don't know what you're going to do. You live in a monarchy anyway, so I don't know what you can do about it. But maybe move south. Maybe that would be interesting. That would be interesting. Agricultural Minister Jerry Ritz announced the G3, a joint venture owned by two foreign corporations, Bunge and the Saudi investment company SLAIC, the beneficiary of CWB privatization. With this, the Conservative government has accomplished the biggest transfer of wealth away from farmers in the history of Canada, said Jan Slump, National Farmers Union president. The CWD's physical assets, its commercial relationships, and its good name have all been given away. The buyers of the CWB actually get to keep the $250 million pittance. They are paying for it. The Bunge 2014 sales totaled $58 billion with a B, bravo, billion, and multi-billion dollar SLIC is a subsidiary of the Saudi Sovereign Wealth Fund. Where is the financial report or accountability? They ask. Well, I'll stop reading. There is none. You've been sold, and you've been sold to a Saudi terrorist. Is anybody putting this together, folks? I mean, somebody's putting this together, but what are crickets if we are? That the Saudis have been the center focal point for about every false flag and major global terror thing that has happened. Which means what? The U.S. and the U.K. are in on it. So, Canuckistinians. Hope you have plenty of stores of rice and wheat and all that kind of stuff. I don't know. This is not looking too good. So money rules, finances rules the world. And as it occurs to me, quite a few of these, I think these reports here came through Twitter. I'm at behind a woodshed, but these were through Gary L. I think as the Twitter feed through. He put up a lot of stuff this week, and a couple of these things came through. I want to thank him for that. That money is how the world goes around, and so someone's really intelligent here working on the new. Now I've heard the elections are coming. Hillary Clinton is going to be made a presidential bid. I hear a couple of other people are too. And, that just brings up none of the above in my mind. NOTA, folks. But this was an interesting and, I thought, great idea to compete. A large pile of cash now announces here this week its bid for the United States presidency. A large stack of money has announced that it will make a run for the White House in 2016. The pile of cash, estimated to be around 1.2 billion United States dollars, said yesterday in a special press conference in Washington, D.C., that it would seek the presidency next year. I'm running for the Oval Office, the money told a packed conference room. I will begin my campaign immediately and start touring the United States as early as next week. The reports claim the center of the large pile of cash's money campaign pitch will be the simple approach to the election process, scaling back on everything but the financial element behind a regular presidential campaign. Why waste the time with people and merchandise that are basically just fronts for the real fuel behind the United States presidential bid? Money, said the spokesman for the legal tender. Scaling back to the bare essentials is the way forward. Money talks, so why not let it run for office? And I say here. It couldn't be worse than what we have, and it would at least be more truthful. Again, we live in a financial construct which we tend to continue to take the benefit of, not denounce, not withdraw from, and then we listen to the pain and the suffering that doing that would allow, and we are crickets to it. Now, inside the crickets, there's these little things that go on. So what we were looking for, people that are taking action. We're looking for the good in the criminals. Are all cops bad, folks? I mean, and here it comes. Somebody who was going to be a cop. I'll bet this was a big decision, too. Police cadet quits academy. Reports cops after witnessing homeless men beaten by officers. And this is for Grimner. This is down there in Albuquerque, New Mexico. Be careful. This is where we've had a lot of trouble down there as well. Investigations going on with this. They're doing too good with their civil rights impositions down there, apparently. District Attorney Carrie Brandenburg has provided new details in a case of 2 Albuquerque police officers who are under investigation for brutality after allegedly beating a homeless man on March 20th. According to Brandenburg, the person who reported the assault was a police cadet who has since resigned. That's all I'm going to say, because I want to move on to something else. You think these cops are doing stuff? That's a police cadet who resigned. We can't call him a cop, can we? Who turned in another cop, can we? That we start, again, as I keep telling you, build your evidence. Start taking a cause on that you want to go address. Here's more evidence that the police can't be trusted. Not that I don't mean that in a oh, that can't be trusted. No, they can't be trusted. You need the evidence of that because they're presumed to be trustable. The seats of decision and the social engineers have said these people in control are truth bearers. Someone who wanted to be one of those couldn't stomach it after he saw what those people actually do. And you know, the jury is so stupid, they would get those cops off if this guy hadn't stepped up. But he wasn't a cop turning in another cop. Those people turn in to be like Dornan. And in fact, they're protecting this cadet, prior resigned cadet, because they're afraid that he's going to be hit. The presumption that the cops are telling the truth wherever they go really needs to be one of the focal points of everybody's discussion when we move into governmental authorities. These officials and employees and officers are quite the contrary, where FBI overstated forensic hair matches in nearly all trials before 2000 comes to the news to let us know what, folks? I mean, the ongoing song that the crickets are responding to. That the government will kill you, hurt you, lie about you, get you into trials, and condemn you. Tsarnaev sound familiar here, folks? But we had the attorneys set up. Oh, no, he done it. He done it. But that's his defense. That on the other side, they got Justice Department and the FBI acknowledging that nearly every examiner in an elite FBI forensic, this is a special unit, folks. This is the exceptional unit. Exceptional America. Elite FBI forensic unit gave flawed testimony in almost all trials in which they offered evidence against criminal defendants over more than a 2-decade period before 2000. You think it stopped? Do you think it stopped, folks? You need a law. You need to, I know it sounds stupid, but you need to go down and get a law that says that FBI, police accounts will not stand as prima facie evidence of the truth. They will be presumed to be lies until they can be proven. You need to actually get a law that says that now. The Bar Associations have extended, those social engineers have extended to the military enforcement so much leniency right now, so much immunity, that the obvious is that it's happening wrong and we still can't get anybody to step up and make a law. All you have to do is make that law, folks. You be the one that offers that and get it to go. On 28 examiners, of 28 examiners with the FBI laboratories, microscopic hair comparisons unit, 26 overstated forensic matches in ways that favored prosecutors in more than 95% of the 268 trials reviewed so far, according to the National Association of Criminal Defense Lawyers, so-called, and the Innocence Project. Maybe so. which are assisting the government with the country's largest post-conviction review of questioned forensic evidence. And then everybody wonders, and no one looks, but everybody wonders when they see why prosecutors can make a 95 to 98% conviction rates. They don't need the stupid jury. And what about the judges sitting back there allowing it, folks? There's supposed to be checks and balances for all this, I guess. Everybody's hands are dirty in this. Everybody's. They'll say it's not, but it is. We can believe all that nonsense, the covering up for each other, the gang covering up for each other. Or we can believe what we're seeing here. The cases include those of 32 defendants sentenced to death. Of those, 14 have been executed or died in prison. Exactions of every kind, folks. That's your USA, USA, USA. Keep it up, crickets. Keep it up. Not bad. Not bad enough they can indict a ham sandwich and get a conviction. Where is the justice, folks? And if you say there is none, what are we doing about it? What are we doing to stop it? What are you doing? What are you doing? Some people send things to me to go and investigate information and this and that, and it's all neat information. It's all this lot of stuff I've read, a lot of stuff I have behind me, if you will. It's a lot of stuff I've had to think about. And I responded last night. I said, okay, what are you going to... You have all this information that you see as valuable. What are you going to do with it? See, are we going to be information collectors, or are we going to start learning that it has to be put in action? And I suggest this way because I did it the other way. For some reason, it worked for me. It got me to come to here, but it took 30 years, folks. You have to understand this. It's taken 30 years. It's too long a time for the rest of y'all. With as fast as this is coming down, now since the mining law, the last 10 years, and focusing on the mining law, I can see that it's very important for somebody, every one of you, but each one of you, find something to battle against that is a wrong you need to make right. Because you don't have the time to get the amount of information you need, or will need, on any particular thing, over just sitting back and enjoying, essentially entertaining yourself with all that information. It's fascinating stuff, no doubt. But I'm finding out that our late coming to the race that we didn't know we were in is going to be a detriment, where we just become information collectors and don't begin to use it, and I get that conversation all the time. No one understands what I'm talking about. They understand that it's right, they can find it, they can read it, they don't quite understand how it works. Well, that's because it's not being worked. Once you start working with it, you see exactly what I'm talking about. That I know that the answer is find something this information you're getting is doing for you. Not just as filling up your mind and giving you interesting things to read, but that it's important to something you're on the ground doing to stop a wrong. I think things will come much clearer to everybody quicker. And I also understand once that starts to happen, it's kind of working backwards from the way I learned it. The rest starts to come up as a proof for itself. It's not a question anymore. And it's very difficult to prove a lot of things, despite what you'll find on the internet. You think it's proof. It's not. Not only is it not just proof on its own, but it's not proof in application or in context sometimes. So, I just wanted to say that. But here, on this idea of good people in government, that propaganda, that meme, that falsehood has to be thrown completely on its head here. We have evidence. I'm telling you evidence here about this. I'm giving you the links. If you go to the Blogcaster page to get it, find it, put it in print it off, get it in bag of log, go do some deeper research, qualify everything that's in there that makes a proof, and then go get the law that changes this. Go become an interceder to that imposition that becomes problematic for the continuation of even the military occupation that I have found through Title 50 tells me exists, that I talk to you about periodically. That we have an interesting article that came up. I think I got this one through Survive Change. Nemo DeNovo sent it up. And it's the final answer on the most cops are good myth, which I think comes and brings this thing full term around to show that we really are have been living a myth that needs to be corrected. And this article goes through some of the discussion on that. And it's really just a delineation of what more of the truth of what's going on, rather than what we are told or we think is out there, or what might be continually in our face about what we think. Because, and I'm very guilty of this, and I do this almost to a fault, I really don't want to judge people. I don't want to think that they're wrong, but you have to, at some point, that evidence of the invalidity of that perception has to fall, despite the fact that you want to give everybody the benefit of the doubt. At some point, there has to be a flipping of that doubt. And this article goes through and works its best to show you that believing that the cops can be a good cop is a myth. And so I tell you that Cadet, he wasn't a cop that did that. You can't say that was a good cop that turned in those other cops. No, he wasn't a cop. He was a cadet. He couldn't stomach it that far. So the cops, you get in, and then you're in. I mean, you're not going to do nothing without maybe becoming a Dornan. So we are dealing with a mass corruption that's been purported and advertised and promoted to be other than that. We're coming to a reality. We're coming to the day that has to be, those presumptions have to be thrown on their head. You have to give the courts of law their direction through the law to say you can't use that presumption. Your decision to say and give a leniency and prima facie evidentiary capacity to a testimony of a cop with a badge has been failed policy. There's no reason and there's no fact to support that conclusion. And what it's doing is actually allowing the commission of crimes and the continuation of the commission of crimes and the syndication and organizational support to do that, aiding and abetting, giving aid and comfort to. That we have the terms in our mind that we could create to change this thing that's going down against us and not be the crickets and not look like we're doing a bunch of fervor, making a lot of suds and bubbles without cleaning any dishes. That you then have to find, no, you're dealing with these criminals. The most important one, the most in your face right now are these people getting a camera, testimony, evidence of the crimes that are now being accosted that we've been hearing stories about. That another article came up, I think it's from EFF, yes it is. They say, do you want to record the cops? You better know your rights. So while we see the cops are not telling the truth, they will testify, they will put you in prison, and they will kill you under death sentences. You heard that on the last story. This is the FBI. There isn't enough polish in the universe to take the tarnish off of this badge for what I read in that last article on the FBI alone. That it's no joke what's saying you better know your rights. I've been telling you that. This is all if you hear EFF. Is telling us the same thing. Electronic Frontier Foundation, notwithstanding my apprehension because of their support by Google, aider and abetter of the NSA, there are some very disturbing videos circulating the internet right now depicting the deaths of unarmed civilians. Civilians. Look at the words, folks. How people confine this and how people describe it to us and how they think it is you're getting right into the military establishment mindset, because that's what you've been living under and don't realize it. Unarmed civilians at the hands of trained armed men. Many of these videos even show individuals being shot in the back or as they try to flee. These are videos of police. These are videos of police officers in America killing unarmed black men like Oscar Grant and Eric Gardner. And they're not just black, folks. I told you about my little almost not being here, and then 6 months later, a gentleman from out of state comes in trying to get help from the state police and gets shot in the back 23 times through the back of his little pickup. And the most recent case shows without these recordings, much of America might not have had any idea exactly how much of a problem this is. Citizen videos of law enforcement. This is crime, folks. And encounters are more valuable than ever. And for those who are wondering, it is legal to record the police. The police don't always seem aware of this. There have been many incidents across the country of police telling people to stop filming and sometimes seizing their camera and smartphone, or even arresting them when they don't comply. In the most recent citizen-filmed incident that gained widespread media attention on April 4th, white police officer Michael Slager shot and killed 50-year-old black man Walter Scott in the back as he ran away from North Charleston, South Carolina. Bystander Feeden Santana filmed the encounter, which started with a traffic stop. After Santana's video surfaced, the officer was arrested and charged with murder. We'll see how that works out, but here's the importance of what I've been telling you about having to have video running right now. And don't leave it up to the cops, folks. That's theirs. They can turn it on and turn it off. Santana said that he is scared of what might happen to him. That was what happened to that police cadet, too. They're put him under supposedly putting him under protective cover because he outed that beating to death of the homeless man. He also considered deleting the video and doing nothing with it. And Santana is not the only person who may be intimidated by the prospect of filming the police with good reason. I'd be careful, folks. You get that evidence, I wouldn't delete it. That's tampering with evidence. That'll get you on a felony. Be careful. Be careful when you step in here. But I'm saying don't not do it. You just stand up for your right to do it. I'm going to not stop reading. You need to read this stuff, because what it goes on to say, and I don't have time to do it here, is that you need to know the laws of your state, even though that it's a constitutional right to do so, that you could be considered, be careful in some sense, you could be considered like a wiretapper to take images that the cop didn't know was being taken, which brings it so-called, I guess, underneath wiretapping, that they say to make sure at all times to have your video taking device, your video device, in the open, at least. If not, announce it. But I would be very cautious doing that, because they'll come and attack you. So you must be also discreet, but in the open. But you need to read this, you need to see what the point is, and you need to understand what your right is to do this. This is the day, folks. I don't know what else to tell you. It's over and over. It's a Billy of the broken record. You need to be protecting yourself, and you need to be protecting those next to you. It's tough enough. The evidence of killing people in video isn't even enough, you noticed, with Eric Gardner. And I told you the day's coming. You can't stop and go at the same time. You can't stand and drop to the ground at the same time. You can't put your hands up and put your hands down at the same time. You can't get out of your car and stay in your car at the same time. This is another thing that needs to be changed. Again, that's the police policy side. Someone goes down to their police department, you look at their police policy for certain things, and you make that suggestion, assert it more than just a suggestion, actually, to change a policy that looks like it gives too much leeway to people that are going to lie against you and lie to save themselves. See, that's another thing here. Without the video telling that, we're back to the cops not being truthful. The presumption that they are needs to be eliminated in the United States of America. And you need to know that when you did that, you realize that the cops are not law officers anymore. They're not keeping the peace. You're in war. So you better step up and make those laws that constrain the military force. As we talked about code enforcement early on, I will spend a little while here in the beginning of the broadcast talking about how you approach code officers, regulation enforcement officers, these agencies, that you have to make an administrative record. You have to know your rights. The miners there, Rick and George, they know they're gonna assert their property rights. There's no question in my mind. They think they're doing that. They are going to do that, but they think they're doing that in the proper way with what they're up against. That they know they have property rights to protect, and they're going to do what they know to do to protect them. That we can then not even be in a condition where we don't know and then don't assert, or we just give over the authority, like I found in a story a long while back, that I wanted just an object lesson. City code, again, code, this is agency This is regulation authority coming down on property, and no one understands their property rights or how to address an imposition, an apparent authority imposing itself. That the city code enforcement cites a Utah family cardboard fort as junk, orders removal. This is not much different than a stop order and remove your stuff from the forest land of public lands, isn't it? But this is done in the city. A cardboard fort built for his children by Ogden resident Jeremy Trentleman has been deemed a violation of city code regarding waste material. And so now you start to hear how the government, these attorney types, these administrative types, try to mischaracterize what you're doing. And if I get to the point where I want to read any further, you'll hear that the property owner doesn't really understand that he needs to step up and argue that at an administrative level and deem the mischaracterization a fraud and then a felony. That he then agrees they have the right to determine what his use of cardboard is on his property is over what he was actually doing with it, to show you this is no different than the problem going on with the miner in the forest. That I tell you, wherever you live, the code enforcement officer of any agency or regulation will be on your door at some point that you're going to have to potentially deal with it. And I'm trying to give you the tools ahead of time to put in your mind to think about. Build your bag of law, whatever laws you find that would support you, your facts and all this other things, your evidence that they do wrong and lies. Build that into a binder already before it happens. It sounds kind of dumb. Well, it'll never happen to me until the day it happens. And then I get a phone call or an email from you. Or you can't contact me, worse, and you can't find the podcast no more. Ogden resident Jeremy Trentleman and his wife, Dee, recently used leftover cardboard to build a play fort in their front yard for their children. According to Utah's Standard Examiner, Trentleman's received a notification last Wednesday from Ogden's code enforcement officer, which informed him that the play structure was not in compliance with Ogden's city code prohibiting, quote, junk or salvaged material, close quote, from being kept on the property. The notification, here, notice, folks, the notification, what did I tell you about that? What's notice? Notice is the first step of the simplified four-step acknowledgement of what due process is. Notice, opportunity, time, and place. Notice, opportunity to respond, and a time and a place to respond. They get the notice, you get the opportunity to respond. How do you respond? You respond in telling them whether or not, or you identify whether or not they have the jurisdiction to do what they've done, or they've mischaracterized your property as their waste. That's a felony. I'm sure. I mean, theft by extortion has got to be countrywide, state by state, to find it. A notification stated that Trentleman's family must remove the fort within 15 days before facing $120 of fine and potentially future legal action from the city. Well, folks, if they defined it as a fort, actually in the raw law, and not just a pile of waste, they've admitted that it was a use that was not waste, don't they? So you can look at this. This is what kind of happened, I think. You'll may or may not have happened with the mine. They may have identified some stuff as mining equipment or mining machinery or mining whatever. That's admitting that there was mineral incident activity on a claim that he had a right to do that. They've agreed that that's not a violation on a violation notice. That's a facial incongruity. So here, if you have that, this is how you respond. This is a notice, an opportunity to respond. But Trentleman's dispute the city's view that a cardboard fort equates to accumulating junk. That's true. That's what they say. So they're saying it. It's not junk. There is a slide over on the side, child graffiti all over the boxes. Trentleman told the Standard Examiner, it looks like a fort. According to KUTV, the family was issued the notification after having the fort up for 1 day and had not received any complaints from neighbors about the fort. Would that matter, folks? If it's your property rights and your property, your cardboard, would a neighbor not liking it actually mean anything unless they could show it was like police power problem? A neighbor, Curtis Price, told KUTV that he thought the fort was awesome. The Trentleman family was originally planned to keeping the play fort for a few days and not as a permanent play structure. Now the Trentleman family has received the violation notice from the city. They're planning to keep the play fort up for a duration of 15 days. They gave us 15 days in the notification, so I'll be darned, it's going to stay up 14 days. Okay, so that impliedly agrees right there that he's going to tear it down on day before day 15 and not use his property and not use his land the way he has the right to use. Instead of answering that their character, just like he said, he knows he said it. People have a true intelligence in them that they don't realize and uses the power. They said in the beginning, he said they do not see how that the city can characterize their fort and use of cardboard as waste. That's the answer. My contribution would be to add, and that for interference is a felony by the official. And so here he's going to allow his... Now, for them it might be fine. 2 days was all they wanted. They're going to go 15. That's way beyond what they were going to do. And you know, cardboard may not last so long. It's the principle behind this that we're looking at, though. And I wanted to use this as the object lesson to show you how people give in even though they know what the answer is. They just don't apply their already innate knowledge to the fact of it. And confront the oppressor, which happens to be this government official. That's the crickets, folks. Okay, he can say, yeah, well, I got 15 days out of him, or 14 days out of him, but that's not the principle that you want to establish, right? Now they come in, and they learn next time they're going to kick you out sooner, maybe, or they get on something else. You're also on notice that you can only have a fort for 14 days at that, instead of your absolute right to determine however long you wanted to have it there and however long you wanted to use the cardboard. What if I wanted to grind that cardboard up and put it in a big heap to collect earthworms, folks? See, as long as you know what you're doing with it, they don't have a right to say you have a legitimate use, and it's not waste. They have no jurisdiction. If they mischaracterize waste, that's a felony trespass. A couple of them, actually. I won't go into it. I've said it before, but... So, there's a limitation to these agencies, and you just have to be there to assert correctly. And so you have to make your administrative record, so in case it does go to court, you have a record that shows the lack of authority. Or you can extract from the record that there was none if it hadn't come to the point that there wasn't any. We come now to, let's go to judicial. Past an administrative development where the agency's beaten down on someone and you're having to respond, and you have to go to judicial review. You've exhausted your administrative remedies, which in the case of the miners in the Sugar Pine Mine, I don't think it has. Even though they're being imposed with an appeal, that would be a really improper way to go right now. I'd move back and reestablish the record was incorrect because they didn't get any due process anyway. Under federal law, these administrative proceedings have to do hearings. Hearings are full trials, essentially. That's Title V for those of you keeping notes and wanting to go look. Title V of the United States Code. And I think it's up around Section 500 or so, maybe 700. You go look around there. And so you'll find go research what hearings are under meanings of the Administrative Procedures Act. Courts have said they're essentially trials. They're the surrogate judicial trial in an administrative capacity that you go to the judiciary and you say, hey, we got some failures in the process here. But when you get to the judicial side, then a judge orders, in this case, the agency to stop. Not the reverse, where the property owner has to stop, but the judge orders EPA to stop clandestine anti-mining collusion. If you thought that the agencies had thought that they were doing anything good, another evidence, no different than the Swanson Salazar case of 2013 explains from the judge that the BLM is acting illegally, and the Hague case of in Nevada of I think the same year explains that the BLM and the forestry work in concert, in collusion, to illegally act against people. Here's another story, another evidence in your bag of law facts of can we presume that these agencies do right? Can we give deference to them? Because the courts have given them deference. Can we actually agree that that's possible? Here's another evidence that, in fact, you can't. Natural resource industry leaders nationwide shuddered in February 2011 when the Environmental Protection Agency announced its intent to veto the proposed copper, gold, molybdenum-rich pebble mine in southwestern Alaska before the developer even had finished its preliminary design. Sounds kind of familiar here, doesn't it? See, this is ongoing. It's not just BLM. This is systemic. This corruption is systemic. This is what we sued. It's sustainable development. It's imposition of the soft law of Agenda 20. You know what Agenda 21. It's global governance. It's all of this thing that brings out climate change. It's a financial construct. It's a carbon taxation. It's this plunder of the world. It's in the federal government through sustainable development. It's not just the BLM, but this is the source that we know to look for. You can look for it real clear, real quickly. That they have to deny property at all points. And why I tell you, assert the property. Why did I go to public domain versus public land? Because the property's in the public domain. And it's not spoken to in the rule. And so in that regard, property not spoken in the rule is the antithesis of the rule, and not subject, and it kills it immediately. Interests are a property, but are they a possession of land? No. Interests are by agreement, contracts. It's kind of like the way most people hold real property when they hold a tenancy that they thought they bought a piece of land. Instead of going back to the patent and bringing up the record to show you're an assignee, as grantee, not as a purchaser under market value. But the EPA, without warning, the EPA had nullified half a dozen basic laws and seized power to itself without authority. The shock went viral. If they can do it to Pebble, they can do it to us. I'm telling you that to every miner, folks. If they can do it to any miner, they do it to all of them. This is what I'm telling you that they want to do. This is why each one of us, on a case-by-case basis, has to resist properly to set this record so that a judge, hopefully, and like hopefully in this case, there's another judge out there that it makes it so obvious that he can say the same thing and can't continue the obfuscation. It was so stunning that Senator David Vitter of Louisiana, then the top Republican in Senate Environment and Public Works Committee, said it's unprecedented even for the EPA to attempt to shut down a project before the developer has an opportunity to apply for a permit. Now, Alaska's a little different. Their minerals are given to the state. Whether or not how the federal EPA gets involved in all this, I'm not really quite sure, because the federal mining laws are still sitting there underneath supporting the Alaskan state ability to manage the lands up there. I don't really talk about Alaska too much. It is a little different. But you see up there that the shut down before the developer has the opportunity to apply for a permit. There, in the Sugar Pine mine, there is no permit. It's a grant, folks. It's already given back in 1866. So where it's already given, there's not the need to have the opportunity to file the permit. See, the notice would be you need a permit. You'd say, but your rule doesn't apply. There's no permit to come. So I can answer this case the same way, but upon the law, even in this lower 48. That they tell you the BLM is completely out. They can't they can't shut this guy down, this miner down at all. And yet he shut himself down under threat, under extortion. That's actionable. Whether or not he goes there, I don't know. How could this happen in a nation of law and due process? Well, I'm suggesting to you that there's not a whole lot of due process that's actually asserted by the people who are getting beat down. But in this case, the appalling answer could be found in a 138-page brief paper Pebble Limited Partners filed last year in its lawsuit against the EPA in the United States District Court of Alaska. And I'm going to remind you, United States District Courts are not Article III courts. So, again, this is like the Bundy issue where you go to the Court of Incompetent Jurisdiction, you get an answer. I'm glad this answer came out good for the property owner. Or the property, he might have a property interest there. But those are held in trust by Alaska, not in reserve to the United States either. So, understand, there's a little difference, but there's pretty much the same if you look at them and analyze them. That the secret behind the EPA's preemptive strike against Pebble Unlimited Partners was a three-pronged lavishly funded by left-leaning environmental groups of environmentalist coalitions, anti-mining scientists, and anti-mining assessment consultants who are secretly giving illegal access to the power of the EPA strategy and decision-making according to the Pebble Group's mining. Well, that's just cooperating agency status, folks. And that's not on the rules. but that's not on the rules, but that's just for public comment kind of things, which they were involved in. So this company, I'll tell you, kind of got involved on the wrong side of this. Luckily, they were able to ferret out the corruption, because if you can't ferret out the corruption, see, they would have lost. And this is the other problem. This is what I'm telling you about doing the administrative side stuff. It starts to bring this out. That if you can't bring this out administrative when it kind of goes to judicial, when it finally gets there, you allow it, you don't have the evidence in your trial. So why appeal from a faulty record? Don't let it go there. Reestablish the record. Establish there was no due process. Establish the continuing the process has to go. Establish the fraud that was incorporated in the system right there, making void everything that's happened up until that moment, and restart the process immediately with the proper statement. Big Green's devastating year-long anti-pebble campaign was the second most expensive environmentalist assault ever. Remember, they got just gobzillions behind these types of people here, so folks. So don't think you can do it with money, but don't think you have to have money. I know the corporations do, but we don't. You just got to know what a simple letter is that needs to be said, the right thing, and that's where it begins and ends, pretty much. Right behind the ongoing war of climate alarmists against climate skeptics, Green forces assume Pebble was dead. It is not. In November, United States District Court Judge Russell Holland responded to Pebble Limited's partnership lawsuit with a preliminary injunction against EPA, ordering the agency to stop its attack. So here we have the remedy against this imposition is an injunction that's independently started by the grantee or the mineral interest, in this case, Pebble. And I don't know what they're holding is. They might own this thing outright. I don't know. I'm not, like I said, Alaska's is a little bit different. But they still have a protectable interest. That's the property. And they have the right to move an injunction to stop an improper attack. Not appeal to the decision, but enjoin the action that can be shown to not be applicable. Ordering the agency to stop its attack, Holland's ruling does not resolve Pebble's partnership's complaint that the EPA pursued an unlawful, unbiased, or predetermined outcome against it, but it does presume the company could prevail on the merits at trial and gives it time to make its case. There's a different thing you have to look at, but there's the stop. See, it's stop. You enjoin. Not only can the Pebble Group now obtain documents through discovery process and questions individuals under oath, but the EPA Inspector General's office also is conducting an investigation into the matter, and several congressional oversight committees have begun to look into it as well. Here it is, folks. This is the answer. This is what these sugar pine people might consider doing. There's a lot of work, but you see how you can start calling attention to it. And here's the thing about what you've been hearing on the news. Oh, they've been filing FOIAs. You don't need to file a FOIA. You don't need to get them to commit that they have or don't have the title. They don't have it. The law says they don't have it. Your title says you do. So what you're looking at, again, is the obfuscation of justice and law. And you're better able to go in on the injunction and then file the suit, and you get it on discovery underneath judicial review. Now, what court you're going to go with competent jurisdiction is going to be a marvel for me to have you find, but that will be interesting. Doesn't matter. There's a better way to go at this, I guess is what I'm telling you. You're not going to do it. Nobody will do it on an improper record. No one will be doing it, will prevail appealing an improper record, let alone appealing into a corrupt quasi-judicial review organization of the IBLA. The EPA is also accustomed to judicial deference, that officials couldn't believe Judge Holland's ruling, that they even sent back a request for clarification that EPA does not interpret the order as otherwise impacting essentially internal agency work on this issue, including work related to public comment review or internal deliberations. Well, folks, this is the point I was just telling you. They have collaborating agencies working on the green side with the EPA. They get carte blanche to all the information. And the Pebble Mine Limited Group doesn't understand that condition. This is where Jefferson Mining District would step in to say you can't do that because what you're doing is not actually a federal public project. This is between the trust of the Alaska and the miner. Judge Holland clarified his ruling. The EPA, he said, is barred from activity whatsoever to advance its work on the Pebble issue, period. So this is a big deal, this Pebble discussion. What I want to point out to you is once we get past the record, as we started like in Sugar Pine Mine, and you might, as I did through the code violation for Utah and the cardboard, once you get through you get a record that's good, you have that going. You also then move in with an injunction to stop, because especially in this case where you find the collusion as well. You move to enjoin this and lock it all down so you can continue to do what you were supposed to do, because your facts then in court show you have the right. Now you're asserting that right. You're not being silent on your right to remain silent. You're asserting that property that's given silence by the agents, that is silenced by the agency that had no duty to silence. So this is today we're kind of going through how the process somewhat works in a very limited way, I know, but give you an idea how you have to strategize what's going on. How does this case play out into the future? What do we have to do? I always talk about to miners. I tell any property owner, approach act into the appeal. Start getting your information into an appeal. Why do I say that? It's because I know that there's a corruption that you're going to have to go through. It may or may not be overcome. I don't know, but at least you don't you're not speaking to the employee. You're speaking in law into the future. So along this line with the EPA, we got sustainable development, and we got the global governance and their property, and they're going to make all this, technocracy, need more information, monitoring. All this stuff is on. It's all the same stuff, folks. It's no different in any of it. We have these little tools that come along that they are using in order to get more and more of this stuff, and it's kind of interesting. There's frailties built into the system, and you start to see your life hanging in the balance with these people. So here's a report here that shows you how tenuous your life is when you submit and allow yourself to submit to this overpressing central authority that is this silent weapons big data thing, that's also global governance, that's the computers help, that we have these things called within the sustainable development and climate change and all these things, you have this thing called smart meters in this case. Stockton, here's how tenuous your life is, folks. You get yourself on a digital system that's controlled smartly, and you may not have the use of what that provides. When your house goes smart, when your refrigerator goes smart, when your heating goes smart, when your water goes smart, when your car goes smart, when your watch goes smart, when your power bill goes smart. That in Stockton, smart meters exploded after truck caused a power surge. And this has been another problem. These meters are fire dangers. Another thing for you to go research if you want to stop this stupidity and the radiation you get from these smart meters. Power surge left thousands without power. So here's just someone taking out a telephone pole. Not just took out the power, it took out all the meters. Even if there was a cutoff and the power was restored away from the initial accident, they could plummet in from other places, you wouldn't have had power for as long as you didn't have that meter. And then part of the reason is, I think, is because they're designed poorly, and they are products of China, and they are really made to fail, I think, that they cannot withstand much surge at all. We're finding out if you do some research. Don't be shocked when one day the side of your house you find it on fire. They explode and they turn into flames. That power surge left thousands without power in Stockton on Monday after smart meters on their homes exploded. Not so smart, huh, folks? So there you go. Just more information on where it is when you go smart. Where we go digital, folks. When we get into the digital realm, what's happening and how we're controlled and how we're controllable. That a while back, and you don't even have to be connected to the earth, that you can be affected by all this silent war in the big data digital world. If you submit your life to that digital world and become a part of it, if you establish residency in all of its benefits, it has the ability to turn you off like a switch, or be surged into dysfunction and turn you off like a switch, and you're done. And this is kind of telltale about how isolated you can be and what the problem can be when you start losing your systems. Kaspersky claims to have found NSA's spy station malware in the space station. If you want to start isolating, the problem is when you are in a small environment and your life is controlled by electronics, that your life is controlled by the proper functioning of the electronics or whoever controls it. Get this, folks, the conspiracy malware probers have uncovered a new operating system-like platform that was developed and used by the National Security Administration in its equation spy arsenal. The equation drug and esquire platform is used to deploy 160 modules to target computers that can siphon data and spy on victims. It is important to note that the equation drug is not just a Trojan, but a full espionage platform which includes a framework for conducting cyber espionage activities by deploying specific modules on the machines of selected victims. Other threat actors known to use this sophisticated platforms include Regine and Epic Turla. The architecture of the whole framework resembles a mini operating system with a kernel mode and user mode components carefully interacting with each other via a custom message passing interface. What they can pack in stuff. Well, anyway, it makes itself up, and think about that. Put it into a computer in space, and now your systems are controlled. Now, isolate yourself down and back on the earth in your house. You need water. You need power. You need your bills paid on time. You need money. Someone comes in and they can do this, and they have a whole operating systems inside your operating systems. You want to rely on that, folks? Is that the world? I think it's a favor that's being done to tax you, to scrutinize you in the banks. I'm asking you to use that as your key to jump out, get out of the banks, and start making your own private economies amongst people with something that's more tangible than an electron. Officials upset, tech companies reluctant to play along with administration's information sharing charade. The government's on again, off again. A love affair with everything cyber is back on. The CIA has just shifted focus, abandoning its position as the world's foremost franchiser of clandestine torture sites and rebranding as the agency of a choice for all things cyber war related. And here we are supposed to be in a war against it, and the government is using all these programs, CISPA, whatever you want to, all this stuff is used in order to give them opportunity to come in and put pressure on these companies that would rather not, well, except Google. Fascinating who the players are here. And so to help that along, Obama just signed an executive order that lets the government seize suspected hackers' money and stuff. If you're on the government doesn't like competition, folks, I just told you. And so they're going to use this forfeiture rulings in order to come after hackers' materials. And that's going to be probably endless. They get your house, they get your everywhere. They'll just, whatever they need to attach, they'll get it. And you have someone who hacks in through your house using your addresses, and pretty soon your house gets taken, and you don't have to be charged for the crime. They just take your stuff. On Wednesday, this was a month ago, unqualified one, Obama issued an executive order which gives the government a dangerous new way to override our constitutional right to due process. Unfortunately, it wasn't an April Fool's joke. The order targets cyber criminals and operated overseas, but have assets and money within the United States, allowing the government to freeze suspected hackers' resources in an effort to combat cyber attacks. They just make you here, and you got your stuff stolen, and the government's done it again on you. Blocking the property of certain persons of engaging in significant malicious cyber-enabled activities is an executive order I'll have for you. You can read it yourself. This is what they're doing. Thank you for tuning in today. I know we're already going to move here. Support, donate as you can to keep the servers running. UCY.tv, certainly reallibertymedia.com. Thanks to Grimmer again, keeping all this going. And WT, worldtruth.org. The social network should be somewhat as free from interaction and Facebook impositions as you can be. So thank you for tuning in. I hope today's earlier discussion on administrative proceedings and how to make it better will help a bunch of people. And we'll talk with you next time. Thank you. Bye. Well, that's another lesson. I hope with today's information you can take it to those that misbehave. From behind the woodshed, leaving his mark on the beast,
This is Hal Anthony. Till next time, journey with purpose.